Good morning, and thank you very much for joining us. I am in Yori Folari. I am Yori Folari. I was going to say that we're going over, so we'll be in Ondo State, so to speak, where, as you know, there's an ongoing saga there following a plan, although a plan to impeach the Ondo State deputy governor, against who a petition has been laid before the National Assembly. Well, it's a plan, but the deputy governor no doubt sees it as a plot to remove him. And he has taken everybody to court. When I say everybody, I'm talking about he's taken the governor to court, the Speaker of the House of Assembly itself, the government of Ondo State itself. So it's something of a saga, quite frankly. And so we thought we'd look in there to see exactly what's going on. And we have with us the counsel to the Ondo State House of Assembly, Mr. Femi Emodamori, as our guest this morning. Good morning to you, Mr. Emodamori.
Good morning, Mr. Yori, and thanks for the privilege to have me.
You're very welcome. Thank you very much. Just before we go, we have a package, a little package. Let's look at that so you get a better idea, get a better feel for this scenario going on. Some are calling it a plan, some are calling it a plot. You get a feel. Look at this.
These are some concerned indigents of Ondo State who are disturbed with the current political situation in the state. They marched to the premises of the State House of Assembly, urged the lawmakers to shelve the ongoing impeachment process against the Deputy Governor, Lucky Ayedatiwa.
I want to encourage every party to please be at peace. Let peace reign in the state. We trust God to step into the situation so that the state can be calm. Because every other neighboring states are a kind of envying the state.
We are here to advocate for peace in the state, because Ondo State has been known to be a peaceful state.
Also, another group under the aegis of concerned youths staged a protest to support the impeachment process. They urged the lawmakers not to allow any group to distract them from doing the needful.
This is the People's Parliament. This parliament belongs to Ondo State. It does not belong to Lucky Ayedatiwa. And the parliament has the backing of the people to carry out its constitutional function. We are saying that the democratic system should be maintained.
In a related development, some former lawmakers on the platform of the All Progressive Congress, APC, urged the State Assembly to be careful with the impeachment of the Deputy Governor.
Fishy about the process. We believe the House of Assembly should rise above every reproach. And it's very unfortunate that impeachment proceeding is their priority.
Our primary constituency, which is the House of Assembly, that they should be more careful. They should not allow themselves to be used. They should look at their constitution.
Also, a group of politicians under the aegis of Atulushi asked the Assembly to exercise caution and desist from setting the state on fire.
Ondo State people were ejected into again, that word in capital letter again, within the space of 2 terms. The first tenure ended impeachment and crisis. Ondo State people suffered the same fate. Again, another round of impeachment.
Meanwhile, a federal high court sitting in Abuja has restrained the state's House of Assembly for proceeding with the impeachment of the deputy governor. Ayodeji Moradeyo, TVC News, Akure.
Okay, so you get some idea of the situation that we're in Ondo State. As I was saying, just about everybody has been sued in the place, not just the governor, also the Speaker of the House of Assembly, this clerk of the House of Assembly. Whoever can be sued has been sued, and the prayer is that matters not be allowed to degenerate to the extent of the wish of the petition or the petitioners as it is before the State House of Assembly. And that is that they should not be able to remove him. He was elected on a joint ticket with the governor. So that's the situation. I introduced earlier Mr. Emodamori. Again, good morning to you, and thank you for coming on. Now, it's quite a situation, isn't it? It's quite a situation. And let me just start off with finding out, generally, are you concerned for security at all? Well, and by the way, I should say that Mr. Emodamori is counsel to the Ondo State House of Assembly. Just that little clip that we showed there, there are concerns that this might degenerate into a breach of the peace. Give me your thoughts on that matter before we come down to the specifics of the case. In other words, what is the state of security in Ondo State as a result of this action?
Well, I need to emphasize that I'm not a security expert in the state. I'm a legal consultant, I'm a legal expert. But then, as a resident of the state, I can assure you that everything is okay. You have political moves here and there, you know. Some may say sponsored, I wouldn't say so. But then they are just the normal thing you see when you have an impeachment proceeding going on, you know. People for and against have the right of freedom of expression. But I can assure you, there's absolutely no fear of security breach. My clients, the members of the State of Assembly, are not under any security threat in any way. And then I'm sure the security agencies in the state are on top of the situation. There's nothing to worry about.
Okay, that's, quite good to hear. Now, what exactly, for those who might have been living in some remote place, what exactly is the principal offense? Because gross misconduct really is what you can grab hold of from the petition. How so? That's the charge against the deputy governor. Gross misconduct, and upon that, they would wish him impeached.
Well, you see, the phrase gross misconduct comes up again and again and again, because by virtue of Section 188, subsection 11 of the Constitution, if you read that together with Section 188, subsection 1, the allegation that must culminate in the removal or attempted removal of the office holder of the governorship or deputy governorship is generally classified as gross misconduct. You then begin to look at what constitutes gross misconduct. But constitutionally, impeachable offenses are defined or are classified under allegations of gross misconduct. You look at Section 188, subsection 1, for instance, talking about the commencement of the proceeding for impeachment, stating that when the speaker receives a notice of allegation of gross misconduct from at least 1/3 of the members of the State of Assembly alleging the holder of the office, then the procedure is kick-started. So gross misconduct, what is the definition? Well, you have the definition in Section 188, subsection 11 of the Constitution, and it is defined as a grave violation of the provisions of the Constitution or such conduct as in the opinion of the State House of Assembly. That's a subjective test. As in the opinion of the State House of Assembly amounts to a gross misconduct. Fortunately, we have been in this murky water several times in this country. The Supreme Court has had reasons to define expand the definition of that gross misconduct again and again. You find a very useful help in the case of Attorney General of the Federation against Atiku Abubakar. That was in 2007. It was reported in part 1041 of the Nigeria Weekly Law Report. And then you go to the case of Inakuju against Adeleke, reported in part 1025 of the Nigeria Weekly Law Report. You have Abaribe against Abia State of Assembly, reported in part 788. In almost all the cases, the courts are unanimous that the issue of gross misconduct is in the absolute discretion of power of the State House of Assembly. Don't forget, Section 188, subsection 11 defines gross misconduct to mean a grave violation of the provisions of the Constitution or such misconduct as in the opinion of the State House of Assembly amounts to gross misconduct. So without being sentimental here, largely what amounts to gross misconduct is in the subjective state of the State House of Assembly. But you must have real provable allegations, not fabricated allegations. And so, in the instant case, good enough, the State House of Assembly has officially released the notice of allegation of gross misconduct, and in the notice you find 14 specific allegations. And then if you look at the allegations, you find allegations of abuse of, office to enrich oneself, that is corruption, misappropriation of funds, allegations that certain sums of money were requested to meet certain projects, but then were not spent. You have allegation that millions of naira, for instance, was requested by His Excellency the Deputy Governor to travel to Ondo, which is about probably 2.5 hours maximum here from Makure, and then you find the traveling expenses, fueling expenses running to about 5 million. Allegation, no doubt about that. You have allegations of about 100 million naira misappropriated the magistrate emergency fund. So these are realms of allegation, but the truth is this. Prima facie, based on the first impression, if we are desirous of fighting corruption in this country, if we want to activate the provision of Section 15, subsection 5 of the Constitution that states that the state must abolish all corrupt practices and abuse of power, then, sentiment apart, you have to agree that there is a need to call the holder of the office to explain his own side of the story.
Indeed.
So, let me say that, like I said, I can't go to the detail, but you have 14 specific allegations.
That's fine. And that's
what
fine.
we are dealing with here.
And
the allegation, the notice was served on His Excellency the Deputy Governor on the 25th.
Okay, because there was an argument about whether or not he had been duly served. As you know, the Deputy Governor had said that he had not received any new service of any instrument, any court instrument. But you are asserting now that indeed he has been. Well, I was also reading in the paper that he was served by something you lawyers call substituted means. So he has been served.
Well, Mr. Yori, let me confirm first and foremost that he has been served and duly served in accordance with the provisions of the Constitution. Section 188, subsection 2, paragraph B of the Constitution mandates the Speaker of the House of Assembly to serve the holder of the office whose conduct have been investigated within 7 days after receiving the notice of allegation of misconduct. Of course, it's in the public domain now, but the Speaker in the plenary session of the House on 20th received the notice of allegation, and it was served on the holder of the office on 25th. That is within 7 days.
Okay.
You talk about what lawyers call a partner service and substituted service. Well, the truth is this. We have had again and again and again interpretation of personal service. Personal service, or if you mandate somebody to take a process, or somebody takes a process and gives it to you personally, it is still personal service. As against publishing it in the newspaper or pasting it on the wall of your office or your house or your residential apartment, whichever way. So we have had, fortunately, definitions of personal and substituted service. Let me digress a little bit before we actually hit whether the Constitution actually stipulates what people are saying. But fortunately, we have had the apex court of the land defining or interpreting personal service to also include a situation where Mr. B took the process without the instruction on behalf of Mr. A and later hands it over to Mr. A. In the case of court proceedings, for instance, there is nothing making it mandatory for the process server of the court to be the one who hands it over personally to the one to be served. I'm talking of judicial decisions. If you serve somebody personally and that somebody hands it over personally to the person to be served, the judicial authority is that is personal service. You didn't see it in the news.
All right. Thank you very much. I didn't want to split hairs on this.
Please, don't give me a minute. Give me a minute.
Okay.
Having said that, there is nowhere in the provisions, the entire provision of Section 188, subsection 1 to 9, where it is specifically stated that the holder of the office must put his own hand on the document and append his signature as the receiver. Because if it were so, it's so easy. When I'm supposed to be served within 7 days, all I need to do is that the moment I know the speakers have received the notice, then I'll just,
make myself
I'll just
unavailable.
and then return after the 7 days. So
Okay.
the truth is that we sometimes import what we call personal service using the rules of court. That is court proceedings.
All right. Thank you very
We
much.
import the rules of court into the legislative process of serving the notice. But whether you use the rules of court here or whichever way you look at it, he has been personally served.
All right.
And I will let you know that, in fact, the receiver of the process satisfied the speaker that he was instructed by His Excellency, the Deputy Governor, to personally receive and then bring it over to him because he has not been in the office. So, and then we had to ensure that that statement, that representation is contained in an affidavit. So we have followed meticulously the process.
So quite
stipulated.
Thank you very much for all of that, explaining it to us. But just to round off before coming back to you, all of the charges of gross misconduct, as you explained, in sort of a detailed way, all of them stem from when the deputy governor served as the acting governor when the governor was away on medical leave, right? That's when all of these instances of gross misconduct appear to have occurred.
Well, Mr. Yori, that is not entirely correct because you have some of the allegations dating back to what was approved even by His Excellency, the Governor of Ondo State, for the Deputy Speaker before he even proceeded on medical leave. What was approved to be disbursed for certain things, which is now being alleged, please, still allegation, that the Deputy Governor misappropriated. So it's not entirely correct. And then that particular head of allegation has to do with money running to close to 500 million.
Okay.
So
all right.
It's not entirely correct that everything happened when he was the acting governor. There are some processes, allegations of misconduct or misappropriation that days back, or the processes started when the governor was still around, approved, but then in between, the money is alleged to have disappeared into the thin air. So, like I said, these are just in the realms of allegations, but then these are allegations calling for explanation in every decent society without sentiment.
Okay. It's just, I just note in passing that it wasn't always like this. Mr. Lucky Ayedatiwa and Mr. Governor were in excellent terms at a certain point in time in the past. But things have gone, south, as they say. Okay. As it is, Mr. Governor Akeredolu is in the country. He's resumed from his medical leave, but he's not yet in the state of Ondo. He's operating from outside of the state. Meetings have been convened, going over to where he is for these meetings. So I just mentioned all of that. You probably agree to all of that. That sort of adds some other color to this, should I call it a saga or an imbroglio that we're looking at? But I just wanted to, for whoever has not been local, to understand that what is going on here, we'll try and understand it, but we must try and understand it in a legal way for now.